Good day everyone, this is a group assignments for International Law GFLA 3124. Before going any further, I would like to introduce the members of this group. The first member is WINNIE, VIVIAN, JULIET, BINTI, JEPRINUS. The second member is JANIA, ESTHER, ANAK, NUMPANG. And the last one is Yamithira, anak perempuan, A.T.Thanapal. This video is prepared for Professor Dr. Muhammad AZIZUDDIN bin Muhammad SANI. Now, let's move on to the main topic of this video, which is what is international law? So basically, international law consists of rules and principles governing the relations and dealings of nations with each other, as well as the relations between states and individuals, and relation between international organizations. Now, let's talk about what is the purpose of international law. The main purpose of international law is to promote justice, peace, and common interests. What are the differences between public international law and private international law? Generally, public international law concerns itself only with questions of rights and between several nations and the citizens or subjects of other nations. Examples of public international law are United Nations Conventions on the Law of the Sea, Vienna Conventions on Diplomatic Relations, and Vienna Conventions on the Law of Treaties. While private international law deals with controversies between individuals, these controversies arise out of situations which have a significant relationship to multiple nations. Examples of private international law are Vienna Convention on the International Sale of Goods and Rome Convention on the law applicable to contractual obligation. These are the important terms in international law. Now let's talk about what is jus cogens. Jus cogens or peremptory norm means a body of fundamental principles of international law which binds all states and does not allow any exceptions. It is basically a compilation of norms that lays down the international obligations which are essential for the protections of the fundamental interests of the international community, and any violations of these norms is thereby recognized as a crime against the community. Jus cogens imply absolute restrictions on genocide, slavery or slave trade, torture, or other inhuman treatment, prolonged arbitrary detention, and racial discrimination. Any activity or treaty carried out by the state or international organization that contradict human dignity and right will offend the concept of jus cogens and thus be void. It can be said that jus cogens exists to protect and uphold human dignity and right. Now, what is pacta sunt servanda? The concept known by the Latin formula, which means agreements must be kept, is arguably the oldest principle of international law. Without such a rule, no international agreement would be binding or enforceable. Pacta sunt servanda is directly referred to in many international agreements governing treaties, including the Vienna Conventions on the Law of Treaties 1969, which concerns treaties between states, and the Vienna Conventions on the Law of Treaties between states and international organization, or between international organization 1986. Last but not least is par imperem non habet imperium. This term means to express the idea of one sovereign state cannot exercise jurisdiction over another sovereign state because of their legal equality. Now, what are the sources of international law? According to Article 38 of the Statute of the International Court of Justice, there are four significant sources of international law. As stated here, the sources of international law are international treaties, international customs, general principles recognized by civilized nations, and Article 51 judicial decisions and policies. While the term of soft law is used to denote agreements, principles, and declarations that are not legally binding, soft law instruments are predominantly found in the international sphere. United Nations General Assembly resolutions are an example of soft law. Now let's talk about the importance and role of international law in terms of protecting human rights. Firstly, international law has its main purpose and role to promote justice, prosperity, and peace all around the world. It is the most powerful weapon to prevent armed conflicts between countries and help them strengthen their mutual relations. Since most countries conclude bilateral or multilateral agreements and special treaties between themselves, international law is a path to governing the relationship between countries worldwide. Furthermore, international law is a crucial way to ensure the prosecutions of war crimes and grievous breaches of international humanitarian law. When it comes to the relationship between international law and human rights, the role of international law in protecting human rights was strengthened when the United Nations General Assembly adopted the Universal Declarations of Human Rights on 10 December 1948. Drafted as a common standard of achievement for all peoples and nations, the declarations for the first time in human history spell out basic civil, political, economic, social, and cultural rights that all human beings should enjoy. It has over time been widely accepted as the fundamental norms of human rights that everyone should respect and protect. In the light of foregoing, the establishment of the rule of law at the national and international levels is required to ensure respect for human rights. International human rights law lays down obligations which states are bound to respect. By signing and ratifying international treaties, states accept and undertake the responsibilities, obligations, and duties as set out under international law to respect, protect, and fulfill human rights. Therefore, the obligation to respect implies that states must refrain from interfering with or curtailing the enjoyment of human rights. In this regard, states are obliged to protect individuals and groups against human rights violations and hence take positive measures to facilitate the enjoyment of fundamental human rights and freedom. Ratification of international human rights treaties imposes the obligation on governments to undertake necessary actions aimed to align domestic legislation with their treaty obligations and duties. Where domestic legal proceedings fail to address human rights abuses, mechanisms, procedures for individuals' complaints, and communications are available at the regional and international levels to help ensure that international human rights standards are indeed respected, implemented, and enforced at the local level. Without wasting time, now let's talk about the weaknesses of international law. The first weakness of international law that we would like to highlight is lack of legislature. In the international legal system, there is no lawmaking authority that can make law for the whole international community in accordance with their new needs. Even though, as delineated in the Charter of the United Nations, the function of the General Assembly of the United Nations is to discuss, debate, and make recommendations on subjects pertaining to international peace and security, including development, disarmament, human rights, international law, and the peaceful arbitrations of disputes between nations, the General Assembly is not tantamount and equivalent to the world legislature or parliament. It has no legislative power and its decisions are not binding on state. This can be seen through Resolution 1761 condemning apartheid in South Africa, whereby it shows us that the resolution did not stop the South African government's discriminatory policy and Nelson Mandela's lifelong imprisonment sentence 2 years later. It has proven that the General Assembly of the United Nations is not equivalent to the world legislature or parliament. It has no legislative power, and therefore its decisions or resolutions are recommended in the nature and not binding on states, since it merely reflects a symbolic gesture by the international community to stigmatize and formally condemn the practice of states who violated the international law. Another weakness of international law that we have figured out is lacking of effective enforcement machinery. Compared to the national legal system, international law enforcement is weaker because in the national legal system enforcement, the government is backed by sovereignty, and that is why the enforcement is also backed by sovereign political authorities such as the police force, army, and need not to mention that the enforcement power is also entrusted by the federal constitution. This can be seen through several events in 1986, for instance, the UK and the US bloc draft resolutions that condemned South African attacks against Angola, Zambia, Botswana, and Zimbabwe. In 1997 and 1998, the same permanent members moreover vetoed the imposition of economic sanctions against the apartheid regime, despite persistent human rights violations. The Palestinian situation, on the other hand, accounts for nearly half of all vetoes exercised by the United States. Thus, it can be concluded that the international law is lack of effective enforcement machinery due to the enforcers of the law, specifically the 5 permanent members which their tasks are supposedly to maintain and safeguard peace in international community, have abused the power given to them by using veto power arbitrarily without restraint in the use of to destroy and create conflict worldwide. Their abuse of power indirectly contributes to the lack of effective enforcement in international law. Last but not least, the weakness of international law is inability to enforce its policies, sanctions, and actions in an efficient and potent manner. Since international law was not designed to control but to facilitate international activity, it has a hard time enforcing any course of action in our realist globalized community, as any power given to it would be consequently power taken from any one given state or the international community. International law cannot be considered as a set of rules because it can only be enforced by moral principles. International law relies almost exclusively on consent to take any course of actions because of this and will likely remain legally weak. Breaches of international law happen all the time, all over the world, and are inefficiently controlled. When a nation's self-interest supersedes that of the international community, international law is broken. For example, 1990 invasions of Kuwait and the United States invasions of Iraq. Again, it is inherent in human nature to abuse and exploit any system, as there would be no crime if there were not the case. However, this is blown into a macro scale, whereby people are interchanged by nations and organizations. It is no wonder when that international law, being governed by politics of many cultures and ideals, must be flexible and therefore no proper law. To summarize this video, we have stressed on the important terms in international law, the sources of international law, soft law, the importance of international law, and the weaknesses of international law. That's all. Thank you for watching.